The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
The North Carolina Court of Appeals. I'm Judge Lucy Inman, and presiding with me this afternoon are my colleagues, Judge Hunter Murphy and Judge April Wood. We are here now for oral arguments in case number COA 20-558, Goforth Primary Trust versus LR Development Charlotte. This is an appeal coming out of Iredell County Superior Court. Counsel, are you ready to proceed?
I am, Your Honor. Thank you.
Very well. Mr. Hash, have you already let court personnel know how much time you plan to reserve for rebuttal?
Yes, Your Honor, but for the court, I would respectfully request 5 minutes.
5 minutes. Very well. Very well. If you're ready to proceed, we will hear you now.
Thank you, Your Honor, and good afternoon, and may it please the court. My name is James Hash of the Raleigh firm Everett Gaskins Hancock. I represent the petitioner appellate Ethel P. Goforth Primary Trust, and as indicated earlier, I respectfully request 5 minutes of rebuttal time. Your Honors, this case is about a debt that has never fully been repaid, that's secured by a deed of trust that was recorded in 2005 that has never been released. The specific issue in this case is whether North Carolina's future advances statutory framework can be used to partially invalidate a recorded deed of trust that secures an identified debt that was incurred prior to the interest of any of the appellees. In short, Your Honors, the answer is no, it cannot as a matter of law. Perhaps the most important point here that I would ask the court keep in mind in reviewing these materials is that there is not a single requirement in Chapter 45, Article 7, the Future Advances Statute, that could have given appellees any more clear notice that they were taking title subject to a $1,002,000 debt than what is actually stated in the recorded deed of trust itself. That deed of trust was on the record when the appellees took title of their property, and it remains on the record still today.
Oh, Mr. Hash, if I could just get the parameters of this argument. Do you agree, and I'll ask the same thing of Ms. Hunt in a minute, that there's just no precedent in North Carolina that tells us whether or not Chapter 45, Article 7 only applies to lien priority as opposed to lien security?
Thank you, Your Honor. I think that is a very timely question, and neither side has been able to find a case. And frankly, I would submit that lack of precedence would suggest that Chapter 45, Article 7 doesn't apply in this context. But it would be a case of first impression in the sense of there's not a case that currently says that, Your Honor. Is that a fair response? Is that? I
just wanted to understand the parameters of what we're hearing, and then you say invalidate, but if an instrument is or isn't secured, it's not invalid, right? I don't think anybody's arguing that this deed of trust is invalid.
I think that is a fair distinction, Your Honor, in that in this case, again, to stick with the construct, I think to more appropriately frame the facts, given the bankruptcy settlement, which I know we'll get into shortly, the real issue I think would be that because of that partial payment out of the bankruptcy, depending upon the amount of the claim that is secured, then the trust's alleged secured claim might have been extinguished, not necessarily because of its invalidity, but because of a partial payment. That brings us to discussing the partial summary judgment order, what we referred to in our briefing as the future advances order, which of course was the primary basis for the trial court's final summary judgment order. And of course, our position, Your Honors, is that the trial court erred as a matter of law because Chapter 45, Article 7 shouldn't be applied on these facts. And we believe that the proper resolution here is that the trial court's order be reversed and be remanded for the trust to be able to proceed to trial on its alleged secured claim. And we believe this for three principal reasons. The first of which, as mentioned previously, is that Chapter 45, Article 7 is not a mechanism that allows the appellees to avoid a deed of trust for which they had clear record notice. Secondly, Article 7 is a lien priority framework. Again, this discusses, as we'll get into, whether and when a deed of trust relates back in order to provide priority for an initial creditor over a subsequent creditor. But here, there are no issues of priority or relation back. I think, put another way, quite simply, by applying Article 7 to these facts, the trial court necessarily reached the wrong result because it was asking the wrong questions, Your Honor. And then thirdly, even if Article 7 could be applied here, that brings us to the question of what would be the appropriate, what we refer to in our briefing as a cutoff date or a determination date, from which point the advances would be declared unsecured. And here, Your Honor, we would submit that if Article 7 does apply, the appropriate date from which advances would become unsecured would be the date of recordation, which was in February 2005. The practical impact of all this, Your Honors, would be that if the trial court's orders are modified in any respect, and if either the court were allow us to proceed to pursue the full amount of the alleged secured claim, or were to provide either a determination date as the date of recording or as the date of the loan maturity, which is also referenced in the briefing, we would have an alleged secured claim to pursue at trial. However, as it currently stands, if the determination date were to remain May 19th of 2004, that would mean that the trust's alleged secured claim was extinguished by the $870,000 bankruptcy payments, which, again, to frame the overall posture, if the partial summary judgment order stands, then the final summary judgment order would be appropriate because the alleged secured claim would have been extinguished. So with that being said, Your Honors.
Mr. Hash, before you go
Yes,
on, I just want to talk about extinguishment of the debt in amounts owed. In part 3 on page 11 of your reply brief, you discussed that if we were to accept either the later date or the maturity date, then there would still be an issue of fact that would need to go down for trial. What is that issue of fact? To me, it seems like we'd just be doing a mathematical calculation of what the amount owed was. So what would be the issue for trial there that you're referring to under 3?
Well, Your Honor, I think that Ms. Hunt would probably tell you that she has a number of factual issues there. Because in all candor to the court, there are a number of other factual issues that I'm aware that the appellees would raise at trial. So I think if that were the case, if the math were to show, as we believe it does, that we have an alleged secured claim to pursue, Ms. Hunt would still very much want to pursue her other defenses at trial.
And that, I guess those included something I remember reading about the authority of the treasurer to sign the note in the first place, the deed of trust in the first place, things like that is what you're referring to. Nothing related to how much was owed on the note, correct?
I believe that's correct, although I don't want to speak for Ms. Hunt that she necessarily agrees with our calculations, but that was what I was referring to in my brief, Your Honor.
Okay. Thank you, Mr. Hash.
Thank you all. The first point I want to discuss is just the fundamental North Carolina legal principle that purchasers of real estate take subject to what's in their chain of title. We cited cases in our brief, and I know this law is well familiar to the court, but generally speaking, purchaser is charged with notice of every fact affecting his title, which an accurate examination would disclose. And that's Waters versus North Carolina Phosphate. One who purchases premises covered by an undischarged mortgage cannot claim to be a purchaser without notice of the equities of the mortgage. An inquiry of the mortgage would have elicited information that the mortgage was still enforced between the original parties. And I mentioned that, Your Honors, simply because when we look at this deed of trust, and there's no doubt that there are portions of these documents that had I the opportunity to redraft them, I certainly would. But as the saying goes, where I come from, you dance with the one what brung you, and that's what we have here. Is we have some documents that could use some work, but at the end of the day, a purchaser examining the title sees very clearly that there's a $1,002,000 note that's secured by this recorded deed of trust, and it's clearly on the record that it's there. So that's a premise that I think the trial court did not pay appropriate attention to, and it's easy, Your Honors, to get caught up in some of the discussion of whether Ms. Hunt's clients are quote unquote at fault. And as she correctly notes, we don't believe that they are at fault in the sense that they did something wrong, but the question of whether someone is at fault can be determined a lot of different ways. We don't think they did wrong, but we do think they're charged with the same record notice that is always charged to purchasers of property under North Carolina law. And we don't think that the Future Advances statute gives them an out to avoid what they were on record notice of, because again, there is nothing in Article 7 that could have given them any more clear notice of the debt they were taking their title subject to. That's consistent with Judge Humrichhouse from the bankruptcy court. Her analysis in Willows 2, she went through a fairly involved analysis of North Carolina state law, and ultimately I don't want to say it was her holding, but certainly among her analysis was when she considered the deed of trust that was before her, she commented that particular deed of trust fairly put everyone on notice as to the amount of the debt and that it was secured. And that's the situation that we are in here, Your Honors. And against that backdrop, I think that takes us into looking at the Future Advances statute itself, talking about what that statute is supposed to do and where it fits within our statutory framework of real property rights. And as Your Honors well know, the Future Advance, when you overlay Chapter 45-68, 4570 together, the general construct under the different versions of the statute that have been discussed in our brief, still the general construct is that a creditor, in order to enjoy the relation back priority provided in 45-70, has to meet the requirements in 45-68. Now, there are a couple important points there, and I have to concede here, Your Honors, right out the gate. Our deed of trust doesn't comply with the requirements of 45-68. So that's, again, Your Honors, that frankly is what it is. But as I mentioned earlier, that in our view is not the right question here, nevertheless, because our case doesn't hinge on meeting the priority or the relation back that's provided in 45-70. So again, all of this analysis we think was, again, asking the wrong question. And when you ask the wrong question, you unless you're incredibly lucky, you don't usually run into the right answer. And here, Your Honor, a number of the cases that we have cited on both sides do talk about the proper application of Article 7. In the briefing, the one of the cases that I think that is the most classic application is the McNeary's Arborist case, initially cited by Ms. Hunt, and which we referenced in our reply brief. And that involved the scenario where we had advances on a future advance deed of trust, and then there was an intervening mechanics lien. And then as we get into renewals of obligations, and the court there, this court was parsing the language of what these documents actually said. And it's important enough that I'd like to quote to the court if I could. Because it explains the analysis that I think shows when Article 7 should be applied. And I'm quoting from McNeary's Arborists. For a deed of trust or other security instrument to have priority, from the date of recordation as to obligations incurred after the instrument is recorded, GS 45-68 sub 1 requests that the instrument show three things, and then goes on and discuss the specific case. And there, it has to be identified, when the obligations are to be incurred. Well, here, Your Honor, again, Your Honors, this shows that 45-68 and the entire Article 7 is about priority. As we look at the statute, 45-74 states that the article is not exclusive. There are other and this holds true. We can talk a little bit about, Your Honors, about the amendments that we have here. The operative documents here were executed in 2004 and 2005, and then the Article 7 was amended in 2009 and again in 2011. And as Your Honors have read, the parties have discussed a bit about the impact of amendments, and I think that there's a disagreement, of course, between counsel about what applies. And we can talk about that in a moment. But I think that what holds true, regardless of which amendment we're talking about, is that I am not aware of, as Judge Inman asked it from the outset, not aware of any case that has ever been, that gives any support to what the trial court did here, Your Honor. And so
and we are also not aware of any case that goes against it, right?
Yeah, Your Honor, that's absolutely right, but I'm an optimist.
Okay.
And so that being the case, here, Your Honor, I think that's part of the reason for that is since 45-74 provides that Article 7 is not exclusive, that means just what it says. It means that it's not the only way to get where you need to be, Your Honor. And we think that our documents withstand where they pass legal muster based on the fact that they had clearly identify a debt. The debt was incurred before appellees took title to their property, and vis-a-vis them, there is no priority issue. There is no relation back issue. It's not a quote unquote future advance. It's just the more basic question of whether our security instruments are valid and they secure the debt that they say they secure.
Mr. Hash, if I can just ask you hypothetically, if and now I'm forgetting, I guess Fox Den signed this deed of trust originally, right? Pretend there's no bankruptcy, pretend there's no other people, and these advances, these payments were made beyond the execution date, but beyond the recordation date, indeed beyond the default date, right? Beyond the final due date, these payments were made. If 10 years later they had not been paid by Fox Den, and Fox Den turned around and said, well, that's not secured. That's not secured. These later payments, that's just not secured because it doesn't fall within the scope of this deed of trust. As I understand the homeowner's argument on appeal, notwithstanding other factual issues that may be out there, it's that this secured instrument, the scope of it doesn't reach these payments. That it's not true that on the day it was executed that $1,002,000 had been received, and that it's not true that on the day it was recorded that $1,002,000 had been received. Can you just speak to that and what's to keep people from later on saying, yes, you signed that, we didn't get the money, what if the Goforths didn't even end up making those advance payments, but they're holding on to this document? So just sort of speak to the effect of that on property law.
Certainly, Your Honor. I think there were a couple of questions rolled into that, so I'll try to. I think
I apologize.
Oh,
That's a bad habit of mine.
Well, Your Honor, I think it shows sort of this is an interesting case, as they say, which is why we're at the Court of Appeals for a second time. However, Your Honor, I think first of all, if the Goforths hadn't advanced the money, then we would lose because there was no debt in the first place. So I think that's the first response there, because we would lose right out the gate because we couldn't show we had ever loaned the money. So, and as to your other, or to some of your other points, Your Honor, the deed of trust recorded as the facts are now before us, it is correct that the entire $1,002,000 had not been advanced. There's a significant amount of information about that that's not in the record before the court, but it's simply the fact that money was not advanced until later. That's why I think it is important when we look at sort of the purpose of what Chapter 45, Article 7 is supposed to do. Because under those facts, I think if the appellees, or if a mechanic, or if a materialman or another lender had come in at any point in this process as intervening, then not only would the deed of trust be incorrect, but the trust would have, frankly, no argument that it should be secured beyond what it had already advanced, because that's how real property works. Is that it's about winning the race to the courthouse. It's about recording. If someone came in with an intervening lien, we frankly wouldn't be here today. One of the points that was mentioned in the appellee's brief, a concern about creating some sort of an incentive for creditors to delay recording deeds of trust. I scratched my head about that just a little bit, because the best practice, of course, is to record as absolutely fast as you can rather than to delay. Because if you delay for some strategic reason and someone else beats you to the courthouse, then you've been well more than too clever by half. So I think that's, to the extent that might be one of the court's concerns. I don't think that is likely to be one of those scenarios that repeats itself. I think that this was a bit of an anomaly here for reasons that aren't really relevant to the court on this particular legal question. But I think that ultimately none of that changes the fact that if you take subject to a debt that exists when you take record, when you take title, it's you and you have notice, then you're subject to that obligation, Your Honor. I hope that touched on what you were asking me, Your Honor.
Thank you.
Mr. Hash, I want to just kind of piggyback on some of what Judge Inman was asking about. And one of my biggest concerns is, even if we go with you that this could secure money, given after the execution, how do you get past this maturity date? This is a huge hang-up for me, is how can advances ever be subject to this instrument I'm looking at record 24 and 25, when the instrument by its own terms is over? And now you're just kind of giving money away subject to some verbal contract or understanding, but it doesn't seem to be subject to this note. So can you point me to anything that would say that in advance after the maturity date can be subject to that note or contract without some type of modification or agreement? That's a real sticking point I have. Even if I can get past the date of execution, I don't see how I get past this date of maturity.
Thank you, Your Honor. And as you might expect, I have spent some years pondering that. And one of the things that it appears perhaps is perhaps these folks intended to make an equity line of credit framework under Article 9 rather than this future advances under Article 7, but I don't think they accomplished that either. So with that being the case, Your Honor, I think that takes us into the intent of the parties as we look at the In re Hall case, which I think has been cited by the appellees in furtherance of Your Honor's very point. But Your Honor, I think there, In re Hall hinged on the court's interpretation of the party's intent. And there, that particular deed of trust that, again, these are all very fact specific, as Your Honors know. And there, even though it was because of the specificity that very tightly limited things, there, I don't think it was a reach at all for the court to find that there wasn't security as to those obligations after that date. Because again, it was, in that scenario, it was up to a certain amount and advanced by a certain date. Now, here, Your Honor, if we look at this particular deed of trust, the documents themselves reflect an intent, a very clear intent for the Goforth estate, the predecessor of the trust, to have loaned the $1,002,000, and the intent by Foxton that was to be secured. Now, certainly, they did not accomplish that within the time frame set out there, but importantly, there was no limitation in this deed of trust. The limitation in In re Hall upon which the court based its holding is not present in this case, Your Honor. So then if we look at the intent of the parties, which of course intent is inherently a question of fact in any event, and we get into whether the documents are ambiguous and how they are to be construed and construed against the drafter, which in this case was Foxton's attorney, which is a different question for a different time. I think, Your Honor, that we would have to look at the intent of the parties to fully answer the question, and I don't think on summary judgment that can be found against the non-moving party.
How is it possible that Foxton would be in default for failure to repay the $1 million when only $380,000 had been loaned to it as of the maturity date?
Your Honor, I think the short answer is Foxton was not in default when this document was recorded. If we look at the record, we see that a number of interest payments were made and some principal payments were made, but no default was declared until some years later. And so again, we're not alleging that there was a default. Again, our argument is simply based on what folks were on notice of.
And Mr. Hash, just to be clear, at the time that the homeowners purchased their lots, all of the money of the $1,002,000 had already been loaned to Foxton. Is that correct?
Yes, Your Honor, that's correct. And Your Honors, I note that I'm in my rebuttal time, but of course I'm at the court's pleasure and happy to answer any other questions now. If not, I would reserve the balance of my time.
We'll let you save it. Thank you.
Thank you, Your Honors.
Ms. Hunt, are you ready to proceed?
I am. Thank you, Your Honor. May it please the court, Amy Hunt on behalf of the appellees, which are a group of, as James knew, I would say, innocent homeowners who have now been facing the threat of foreclosure since 2013 for a debt they had nothing to do with. I think you all have already hit on a lot of my points. The primary being this case isn't about notice. This case is not about who had notice when. There is no dispute this deed of trust was on record. There's no dispute we took title when it was out there. This case isn't about identifying the debt, as many of the cases, including Willow's, deal with. This is a case of whether or not the creditor complied with the statutory framework for the type of loan it chose to advance. And there is also no dispute in this case that this particular creditor, the appellant, chose the structure of a future advances loan. That is how the money was doled out in terms of future advances. What they didn't do was comply with the statutory framework. And we don't think this is about notice. It is about, does this creditor have a secured, not valid, but a secured debt, secured by these homeowners' individual lots, such that they are entitled to foreclose under Chapter 45? And we say they don't. We think that there's no question the money was loaned, but the question is, was it secured? Because if it's not secured, it's going to meet one of the fail to meet one of the statutory requirements for foreclosure. And that's
Let me just ask you a quick question.
Certainly.
Do your homeowners, your clients contend that despite the fact that they were on notice of this deed of trust, that the money was owed to the plaintiffs, that they took the property without any liability?
Your Honor, my folks were unaware of the deed of trust at the time of purchase until the foreclosure was initiated. They obviously don't claim any liability on the debt. And in part of defending this foreclosure action, the second time around in the judicial foreclosure, the appellant has the burden of proving it has a secured debt upon which it can foreclose. And we think because it did not comply with the future advances statute, it doesn't have a secured debt. It may have a debt. And we know there was a debt because $870,000 has already been paid to appellant as part of repayment of that debt. But that doesn't make it, may be a valid debt, but it may not be secured. And if it's not secured, these folks can't lose their homes.
So your clients contend that they were unaware of a recorded deed of trust that involved their property?
I understand they have record notice, Your Honor, but these individual homeowners had no actual notice. It wasn't disclosed at closing.
Did they not have attorneys prepare
There was
their closing
there was an
documents for
attorney.
them? Okay,
There was an attorney.
thank you.
Isn't this what title insurance is for?
Maybe. But in order, whether they have title insurance or not, the foreclosing party still has the burden of proving they have a secured debt. They don't get a windfall of being granted a secured debt just because the other party may have title insurance to protect them.
So you're
And
just
we
saying
don't.
I'm sorry.
I'm sorry.
You're just saying we don't even get to notice. You're saying we
No.
don't even get to notice because we don't have a secured debt.
No. The type of notice we will be talking about here, this is a judicial foreclosure claim. The type of notice we will be talking about is the notice service of the foreclosure. No other notice comes into effect with the Chapter 45 foreclosure framework. The question is, can they prove the elements? Do you have a valid secured debt, so forth and so on? And secured debt is the question. That's the prong that is at issue here. And when we look at Article 7 of Chapter 45, there's no stated purpose. We know the legislature has the power to state its purpose, and sometimes it kindly does so within the statutory framework, but in this one it doesn't. And we don't get to read into that statute. We don't get to put words where they aren't. We're stuck with the plain language when the legislature doesn't give us a more stated purpose. And when we look at the plain language of this statute, what we see is the legislature has told us specifically how to create a future advances deed of trust. If this were purely an article based on priority, there would be no need to have a separate subsection entitled priority. If the whole thing dealt with priority, you wouldn't need a separate subsection that specifically deals with priority of this type of instrument. We would argue that because 4570, which is specifically titled priority of security instrument, deals with that issue of when you have a subsequent lien holder or a subsequent creditor come along, what's secured and what's not, by nature of the fact there's a subsection, the entire section can't be a priority framework. It's interesting, the cases that have been discussed in both briefs, the ones that touch on these statutes are dealing with 4570 and the priority piece of it. There aren't any cases, as Judge Inman and Mr. Hash have both discussed, there are no cases that deal with a foreclosure setting and whether or not a debt is secured because of its failure to comply with the future advances framework, statutory framework. On the face of this deed of trust, it satisfies none of 4568's requirements. I think Mr. Hash has already agreed to this. It does not say future advances. It does not even hint there will be future obligations. It doesn't state the amount that was currently presently secured. And the statute doesn't say presently secured as of when. Presumably we're talking execution here. It did contain a maximum principal amount, but it never had a period within which obligations could be incurred. As your honors have already noted, in fact, at the time this deed of trust was recorded, the maturity date had passed, which is unusual in and of itself.
Sorry, that unusual as that may be, are you hearing a big echo?
Yeah.
We can just stop the clock for a minute.
I'm not hearing the echo now, Judge.
You're good
Okay,
now.
good. Do our best. Unusual as that may be, is there any statute or case law saying that's invalid?
No, Your Honor, I'm unaware of any statute or case that says a deed of trust recorded after its own maturity date is invalid. And I'm not making that argument today, but this court has been tasked with considering whether or not the debt alleged by appellant is secured. And to determine whether that is true, we have 3 dates we have to look at. We contend, as the trial court agreed, that the proper date is the date of execution, which would have been May 19th of 2004, at which time $280,000 had been advanced. There is no dispute that's the amount on that date.
And why do you argue that the 2009 amendment doesn't apply here?
So, Your Honor, the 2009 amendment purports to relate back to all other instruments, but we think under the Falk versus Fannie Mae case, and there are other cases along these lines as well, the legislature can't affect the validity, construction, enforceability of a contract ex post facto. You are governed by the law as it existed at the time you entered into the contract, which makes a lot of sense. Everybody's playing under the same rules. If at the time you entered the contract, you all know what law you are entering into a contract under. So we don't believe the 2009 amendment relates back. And of course, the reason that is important is because the structure that was in place in 2004 and 2005, which was the 1989 version, in the priority section, which is 4570, and again, we're not talking about priority in this case, but in the priority section under the 2004-2005 version, the legislature said, if your document conforms with 4568, if you state on its face its future advances, if you put all the other information in there, then you get the benefit of being secured as of the date of execution. That's the beauty of a future advances deed of trust against subsequent lien holders. In 2009, the legislature revised that to be if you conform, and again, this deed of trust does not conform, and this is not a priority case, but it's the only place in the statute where the legislature talks about execution versus recordation. So in 2009, they amended 4570 to say if you conform, you have priority as of the date of registration. We don't think that section particularly applies either way because this isn't a priority case, but we think at the time of this deed of trust's execution, maturity, and recordation, the law as the parties could have discovered it would have said you get priority as of the date of execution. So that's why we believe that's the proper date. And under that date, yes, Your Honor.
I didn't mean to cut you off. If you want to finish that, and I'll have a
No,
follow-up question. If we're looking only at the date of execution, doesn't that become a problem with most real estate transactions that may not actually fund until later in the day, hours after the time of execution, or even a day or two later? So there actually isn't funding of the note and the deed of trust until it's actually recorded, or the closing package is sent over and the bank approves it. If we say it's the time of execution, doesn't that become a larger, more widespread problem? And tell me why not. Why shouldn't I be concerned about that?
Well, Your Honor, it's a change in the statutory structure. As of 2004 and 2005, the legislature required more stringent information in your actual future advances deed of trust. You had to say how much was in as of the date of execution. So when you're signing it, you'll say how much you've loaned. You have to say the period in which you can do it. And the old statutory framework required pretty detailed information put in the public record every time new money was advanced so that someone could see with detail how it was advanced. Now that's all changed. I mean, if I were a gambling lady, I would say the legislature is trying to make it easier for bankers to loan and institutions to fund money under this structure. And some of those requirements have been dialed back. So under the current structure, you wouldn't encounter the problem that you're discussing because the face of the deed of trust isn't required to have as much specificity. It does have to say its future advances. And you don't have to go into the public records and make modifications or notations every time additional money is advanced. And that 2009 amendment made it recordation. So I think going forward, this is not a problem. The question is this particular fact pattern under the statute as it existed in 2004 and 2005. but I don't think this creates a bigger problem. I think the odds of encountering this set of facts again under this particular version of the statute are very limited.
We can only hope so. Ms. Hunt, if I just follow up on Falk, there's the court goes on in Falk to say, you know, everything you said, and then it says, but, you know, it's generally accepted that there's no constitutional limitation upon the legislative power to enact retroactive laws which do not impair the obligation of contracts or disturb vested rights. I take it that you would argue that extending this from the execution date to the recordation date would impair the obligation of the contract vis-a-vis, I guess then it was Foxton.
Foxton at the time.
Yeah.
Yes, Your Honor. I think, first of all, by the time the 2009 amendment came, certainly all of the rights related to the transactions here had been vested. I mean, all the money was out, payments had ceased to be made at that point. This was not a loan that was still money going in, money coming out by the time of this. So I think there's no question, as of this particular statutory amendment, rights were vested.
And when we look at your clients and say if their rights were vested, I mean, for this analysis, will we?
They were. They took title in 2007, 2008.
Okay.
So they were. So yes, the facts were as they are today at the time of this amendment, essentially, aside from the bankruptcy and some other things going on. But in terms of money out, money in, title changing hands, recordation, maturity date, the rights were vested. And again, Your Honor, even if the court wants to follow the 2009 amendment, it still doesn't get appellant where it wants to be. We're still left with the portion of the debt that was secured having been satisfied, such that there is no longer a secured debt to foreclose upon. Because the reference to registration appears in the priority section, and we're not in the priority section. We only point to it because it's the only place there's any guidance within the statute in terms of execution versus registration.
Ms. Hunt,
Yes, sir.
I'm looking at your brief, page 13, where you say that if we use the date of maturity as the date, that the 380 in principal together with interest on that amount would be secured, but then that would be set aside by $870,000 payment.
Your Honor, and
by bankruptcy. My back of the napkin math puts it around 995,000 would be the amount owing as of that date of the bankruptcy settlement. Is my back of the napkin math way off, or are we looking at a potential gap if we do use the date of maturity?
I think it would send us back to a remand to figure that out. But my back of the napkin math last night puts me around where you are. So I think there could be a gap if we use the maturity date.
Thank you.
And as was alluded to earlier, if this is remanded, it is not just a money calculation. I think we can all do that sort of quick math, although we have not stipulated that all of those calculations and interest rates are accurate. But that's when we come into play with all of the other equitable defenses, which have been raised now a couple of times in this court.
Thank you.
So, Your Honors, ultimately, this court is being asked to consider the future advances statute irrelevant for all purposes other than priority disputes. And if that's the case, a good chunk of this statute doesn't need to exist at all. We think if a lender is going to choose to do a future advances structure of a loan, the statute sets forth how to do it and how to accomplish it such that that money is secured by whatever collateral they are attempting to secure it by. And in this case, the appellant chose how they wanted to set up their loan and simply ignored the statute. Didn't even slap future advances on the face of the deed of trust. There is literally nothing on this deed of trust that indicates it's for future advances. And there's conversation about whether it's made when the advances were made relative to subsequent purchasers. That's not even in the priority section of this statute. They only talk about subsequent lien holders. This isn't about relatively with respect to future purchasers. There's no dispute it was on record. Notice isn't an issue. The question is this debt secured? Is it secured by the land they are seeking to foreclose upon? And without any hint of compliance with the statute that allows debts made after the execution of the statute to be secured, we don't see how we get there. And therefore, appellant would fail to be able to prove the prongs under Chapter 45 to entitle it to foreclosure. And we believe the trial court's decision, both orders, respectfully, we ask that they be affirmed for the blatant failure to comply with Chapter 45, Article 7. Thank you, Your Honors. I'm happy to answer any other questions.
Judge Murphy or Judge Wood, any more questions?
Give me 1 second, Judge Inman. Let me just double check my
Sure.
notes just to make sure I didn't have anything else I wanted to ask of the appellee real quick.
Absolutely. While we're waiting, how long have you been in this case, Ms. Hunt?
Let me see. Well, the first lawsuit was 2013, right, James?
I know
think the
you were in
special
where I was.
proceeding. Yeah,
Okay.
the special proceeding started in 2013. I've had a baby since then, and my youngest is 7, so I've been in it a while.
I'm good, Judge Inman. Thank you for the additional moment
Okay.
there.
Judge Wood, any questions?
I don't have any further questions. Thank you.
Thank you very much, Ms. Hunt.
Yeah.
We will now go back to Mr. Hash.
Thank you, Your Honor. Again, may it please the court, just try to be very brief. I should note for the court that this is a judicial foreclosure. And as we alluded to in our brief, after this case was decided, Justice Newby issued in re lux, which our understanding is in re lux meant that what happened before means that there was no preclusive effect from the power of sale. And I think a lot of the issues that are referenced here could proceed much differently in the trial court below. But I do want to note for Your Honors that in Ms. Hunt's presentation, there was no discussion of the language in Article 7 that says that it's not exclusive. Again, and I think that given the absence of case law and the fact there's a specific provision that says it's not exclusive, I think that it's a bridge too far to take the step that the appellees are asking the court to do here. And particularly, even though in the judicial foreclosure, the plaintiffs bear the ultimate burden of proof on summary judgment, of course, the movement bears that burden. So again, with no law, with a statute that says it's not exclusive, and a heavy burden on summary judgment, we simply don't think the appellees get there, Your Honor. We think that the trial court erred as a matter of law. And to touch very briefly on the Falk case, I would be hard pressed to articulate exactly what vested rights here would be affected by the application of the 2009 amendments to this article. Because again, if the article doesn't apply, there would have been no vested rights conferred by the statute in the first place. But to the question that Judge Wood asked at the end of my initial presentation, the fact of the matter is what the appellees took title 2 years after the final balance of this $1,002,000 was actually loaned. So going or coming, Your Honor, asking the court to apply a statute which has never been applied before to do this in the face of a non-exclusivity statute, in light of the heavy burden, and then the fact that it's not clear what vested rights they're claiming would be infringed upon anyway, Your Honor. We think for all those reasons, the more appropriate thing here is for the trial court to be reversed in this matter, remanded to trial. Because again, Chapter 45, Article 7, as you read it, Ms. Hunt's arguments are, of course, are well taken. But at the end of the day, when we read the statute, if the statute is not about priority, I would question what it is about. And with that, Your Honors, I would simply ask that this matter be remanded for trial. But thank you for your attention, Your Honors.
Thank you. Mr. Hash, if I can just ask you one more question, I'll give you a few seconds to answer it because I know we're running out of time. Article 7 is titled instruments to secure future advances and future obligations. Does that word secure figure in this analysis about whether this is about priority versus security?
I think that it could, Your Honor. Again, we can get into an esoteric discussion about titles of things, but having brought up the question of purpose, I think it's a fair question, Your Honor. And I think, again, this part of that hinges on the analysis of what is a future advance and a future obligation. And as one of the things that we argued both to the trial court in our briefing here is that this future obligation and this concept, again, that as Ms. Hunt has been very taking great pains to point out, very specific provisions have to be applied, have to comply with to make something a future advance. And we say here, Your Honor, that these aren't future advances. So that would be my response to your question, Your Honor.
Thank you very much.
Judge, if I can have just a minute, ask
Sure.
one more question. Mr. Hash, in regards to the 4574 argument about article not being exclusive, the statute reads, nothing in this article shall invalidate or overrule any rule of validity, and then goes on to talk about priority. What rule of validity would you be asking us to apply to this deed of trust, with common law, prior statutory rule, prior interpretation, that would say that this deed of trust would secure these future advances?
Your Honor, very simply, we're asking that the court say that the deed of trust secures what it says it secures, which is a debt of $1,002,000. And that's consistent. I hate to be so trite in saying that the deed of trust says what it says, because that certainly cuts both ways, depending on how one looks at it. But at the end of the day, yes, Your Honor, all of the case law says that the deed of trust has to identify the debt that it supposedly secures. And here, Your Honor, it identifies a debt of $1,002,000 and appropriately referenced our promissory note. Whether our promissory note has issues is frankly a different discussion for a different day. But here, Your Honor, the plain language of the deed of trust and the case law that's cited in our briefing would be what I would point the court to.
Thank you, sir.
Any questions, Judge Wood?
No, I think Judge Murphy asked my last question, so thank you.
Well, counsel, thank you for your excellent arguments, and the case is submitted.
Thank you, Your Honor.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is now adjourned.